Hi, I'm Robin Peterson, and I'm board certified in elder law, certified elder law attorney. And today I would like to talk to you about drafting to protect your estate plan against a successful contest. And I'm not trying to make you into a trial lawyer. This is really directed at showing a draftsperson, especially somebody more new in the field, how a will or trust contest works, how it succeeds and how it fails. So if you want trial skills, this isn't the place. This is more from a drafting point of view. And the context is parties are in a lawsuit to overturn the will or the trust, and the drafting attorney, the drafting attorney, is the witness. And I want to go through with you what the elements are for a successful challenge so that you can at least answer your client's questions. They're going to be asking you, can my will ever be overturned? Can somebody contest my will? And we're trying to tell you how to do it right to ensure that it won't be overturned. So there's only 6 real theories, substantive theories of attack: fraud, duress, undue influence, lack of capacity, mistake, and then lack of formalities in the execution. So we'll cover those, and they're not that difficult. And then we'll cover some practical approaches that will hopefully, I like to think of it as bulletproofing the plan, but it's a little grandiose. But if you think there's an attack from nefarious forces, these are some things that you might want to keep in mind. And one thing, before we get into the theories of attack, one thing we talk about sometimes is whether to do a medical examination or whether to film the execution. And that's really a two-edged sword. I tend not to do it. I've done it a couple times. And the problem with doing it is if you're ever deposed, they're going to ask you, is that something that you normally do? Do you normally get a medical examination? Do you normally film your execution? And you're going to say no. You can't film every execution, every signing procedure. I think most executions are signed, but we're not going to get into the world of puns. I do it like once a year, once every 2 years probably. It takes up a lot of space on my computer hard drive, but also most of these cases that you think might get contested don't really get contested. And your client may not show as well on film as you think they will. So let's get into the causes of action. The most common that are sued over is lack of capacity and undue influence. We're going to cover those first. And then another line of attack that comes up a lot is improper execution. And then the final 3, the mistake, fraud, and duress, those are not used very frequently, or not used successfully very frequently. So if we talk about undue influence, we imply that the testator possesses the capacity. So it's always useful and common to allege both undue influence and lack of capacity. That's really the reflexive mode that a litigator will, theory that the litigator will use, both of those. So let's hit the first one, lack of capacity. That's the one that we probably pay the most attention to, but it's second in success rate between that and undue influence. Lack of capacities, just what it says. And bear in mind, a very senior attorney told me when I was very young at this, he said, we're not trained to be doctors. We just observe the client. If they've got enough together in order to create an estate plan and sign it, do it. Just take good notes. If you're ever deposed, just tell the facts. Don't try to play doctor on this. Because if they don't, and this is a quote from him, if they don't do it with you, they're going to go down the street and do it with somebody else. On the capacity issue. One thing that I'm going to hit on is there's an extremely strong presumption for capacity. I'm a Florida lawyer. This is really, the quotes or the cites are going to be Florida law, but I did research the national law on this, and everything, just about everything that I say here, except for 1 or 2 cites, is going to be, well, it's going to be good law nationwide, but the cites will be Florida specific. If we did not have such a strong capacity a strong presumption for capacity, the courthouses would be full of disgruntled heirs challenging estate plans. So in lack of capacity, the decedent only needs to understand 3 things, And these are probably, you remember these from your will and trust class in law school. The testator needs to recognize the general nature of his property that he's to be disposing of, A. B, the folks around him that are the natural object of his bounty, and I think of it as family and friends, and C, a general understanding of the practical effects of the estate plan as he's executing it. And the estate plan, we're not just talking about the estate plan, we can also be talking about advanced directives such as powers of attorney and healthcare surrogate designations and beneficiary designations of IRAs and life insurance. So the general understanding of the practical effects of the plan really talks about the whole plan, not necessarily just the will or the trust. And these theories of attack apply as well to beneficiary designations, joint tenancy right of survivorship designations, and the advanced directives. The burden of proof, nationwide, the burden of proof is on the party challenging the will. There's a very strong presumption of testamentary capacity. It's one of the strongest presumptions found in the law. Just because you're old or frail, or your memory is failing, or you change your mind a lot, those don't in and of themselves negate the presumption that that the person has capacity. Likewise, an alcoholic, if they have a period of lucidity and they execute a will, it's still presumed valid. So as a drafter, if you know that's in the cards, talk to the person. Just say, hey, come in at 10 o'clock in the morning, let's get it done, and then you can go to the bar and have your fun. Same with somebody that is insane or is teetering on contact with reality. If they have a lucid interval and you've properly documented the file and your witnesses, in that case probably want to make a statement to that effect, then the presumption still applies. Probably the only exception is if somebody's been adjudicated to be incapacitated. You really don't want to be doing a will unless you have court approval. That's the one where the presumption probably of presumption of capacity probably fails. So really, this is where the action is: undue influence, and this is probably the most common grounds for attempting to set aside a will or trust. And frankly, it's probably the most common grounds that a will or trust should be set aside. It happens all the time. The more time you practice in the field, the more you'll see it. You'll see it personally, as I have, or you'll see it in the courtroom by testimony. So what's undue influence? That is where a testator, the testator's will is not in control. It is substituted by another person, so that the other person has destroyed the free will and controlled the mind of the testator. And the product, the trust or will, is a result of the undue influence or doing their voodoo. The complainer, the plaintiff, generally needs to show, these are not elements, but this is evidence, that the will leaves the property in a way that you wouldn't expect. Close family members or close friends were left out in favor of others without an obvious explanation, other than if they were a caregiver. That's the most common nefarious situation where a caregiver ends up, it's automatically suspicious when the caregiver inherits everything. I said suspicious. It's not. You can see the gun smoking, but you might not have seen the bullet leaving the barrel. It may be a conscious choice on the part of the testator. The last will contest that I ended up trying, there was a caregiver that successfully resisted the challenge, and I think rightfully so. Of course, I represented the caregiver. So another thing that you will see in that situation, though, is the will maker is dependent on or trusts the person that is alleged to exert the influence. Confidential relationship is the common term that's used in that situation. And not required, but very, very present, very, very often that's present, is the person is ill or frail. And without saying this, without having to say this, the undue influencer, of course, has to benefit by the alleged act. So the three elements, these are the elements. The alleged undue influencer needs to be a substantial beneficiary under the will. They need to have a confidential relationship and was active in procuring the will. And there's a fair amount of case law on the active procuring. And the reason we talk about active procuring so much in the case law is it's usually done under cover of night. And so the courts nationwide have grappled with what kind of evidence would indicate that there's been active procurement. The other two, let's go back. The other two, the substantial beneficiary, the will speaks for that, speaks directly to that. That's hard evidence. And the confidential relationship is pretty hard to deny in most cases. So active procurement is the one that the courts really pay attention to. So confidential relationship, as I mentioned earlier, it's where the two parties have a relationship where the testator has trust and confidence, and the undue influencer is relied upon very heavily. It's usually an aging situation, but it can be a disability, prior to age 60, a disability situation as well. Spouses, that's the tough one. Spouses of a first marriage are presumed to influence each other. Spouses of a second marriage with blended families, there's a lot of litigation in that. But you'll see if you read the cases, the courts give the second, third, fourth, whatever spouse a lot of leeway to. It's presumed that they're going to have a lot of influence over each other. And of course, the challengers are the children of the first marriage, almost without exception. So we got blended families, as we've kind of covered. We've got blended families and we've got caregivers. Those are the real common will challenges on undue influence. So what is active procurement? In our state, the estate of Carpenter, the site that you saw a couple screens ago, covers 7 common evidentiary elements or evidence instances of active procurement. There are more than that, but the 7 that are like biblically announced by in almost every will contest argument, in opening and closing argument, are the following 7. The presence of the beneficiary at the execution of the will. Now remember, we're talking to the will drafter, the estate planning or elder law attorney that's drafting the will or trust. So think of what you can do to negate these 7 factors. The presence of the beneficiary at the execution of the will. Well, that's easy. Don't let them in the room. Don't let them out of the, if they show up, you've got a litany of questions that you can ask in the very beginning out in your waiting room, and usually you're going to want to leave folks out there, at least initially during the consultation, so that you and the testator or testator and spouse are back in the room alone with you. This is one that we see a lot. Presence of the beneficiary on those occasions when the testator expresses an intention to make a will. All of a sudden, when alleged undue influencer is around the testator, they start talking about making a will, and then they forget about it when undue influencer is not around. It's because we know what's happening. I've actually seen it in my office. They didn't know I was watching them. I got up to make a copy, and I heard the distant relative whisper in the ear of this elderly lady, "Don't forget, you want to give me everything in your will." And chills went up my spine when that happened. But usually that doesn't happen. Usually you don't see that happening. So the beneficiary, the undue influencer, finds the attorney and recommends the attorney to draft the will. That's why it's important to always know your referral source. Find out when the person calls where they came from, where the person heard your name. Because if it's the undue influencer, your antennas really need to go up then. Because your goal, of course, is to protect the estate plan. You're not going to go do an estate plan that you think is going to be overturned. It might even be a malpractice if you ignore all of these things. But your pride should keep you from committing any of these sins. So if the beneficiary knows the contents of the will prior to the execution, that's a pretty strong element or pretty strong evidence that there might be undue influence going on. This is something you can combat really easily. Number 5, giving the instructions of what the will is going to contain. And that undue influencer gives those instructions to the attorney drawing the will. That should never, ever, ever happen. Ever. You got to, you just don't even want to be in the position where you're talking to that beneficiary. Securing the witnesses to the will by the beneficiary. I'll bet you most LegalZoom kind of wills, that's something that I see all the time. And I think a LegalZoom kind of will is particularly suspect or subject to undue influence. And then the beneficiary keeps the will after the execution so that it's safeguarded. That also is a very common indicia of undue influence. And in the practical section, I'll be going through a few things that you can do, especially for number 7 of the safeguarding of the will. So there have been, nationwide, there have been three other that I have noticed, three other indicia of undue influence that I've noticed. I've seen it also in guardianship cases too. Isolating the testator, in guardianship in Florida is conservatorship in some states. Isolating the testator and especially disparaging the family members or other family members. And that's one thing that'll piss off a judge like there's no tomorrow usually. The inequality of the mental acuity, that in and of itself doesn't prove undue influence, but it certainly is evidence as to indicating that there might be undue influence. And as we talked about earlier, how reasonable are the will or trust provisions? So the undue influence we spent a little bit of time on. Improper, because it's the most important. Improper execution, that doesn't happen much. I'll give you the law on it, and then I'll give you what, it's kind of nuanced, and you don't really need to know this nuance. But the will needs to be in writing, and most states are this way. It needs to be signed at the end by the testator or signed by somebody else at the testator's direction. The testator needs to acknowledge signing it in the presence of the two witnesses. Needs to acknowledge signing it in the presence of the two witnesses. I didn't say sign it in the presence of the two witnesses. First bullet repeats what I just said. Witnesses do not need to see the actual signing as long as the person acknowledges it. However, the witnesses do need to sign it in the presence of each other and the presence of the testator. And self-proving affidavit is very useful, but not required. That just adds another witness too, if it's ever attacked. But it allows, self-proving just allows it to be introduced into the probate quicker. That's not part of the execution process. So let's talk about, let's cut to the quick and just talk about how to do it. Just pile everybody in the room together, the testator, the witnesses, the notary, have everybody sign in the presence of each other. You do that every time. Train your staff to do that every time. And in 5 or 10 years, when the will or trust is challenged, you just talk about your normal process of execution. You're probably not going to remember in particular about that particular one, but the judge will be happy if you have trained your staff and everybody says the same thing in depositions. So the fourth is a mistake. That is very rare. Looking at the case law, in my experience in the last, it's probably been 35 years, a true mistake, is about as common as finding $1,000 bills, a pile of $1,000 bills on the street. Mistake is where the testator thinks he's signing one document and he's really signing another. He signs the will thinking it's a get well card. That's kind of an absurd example, but if something like that, or signs a will thinking it's a mortgage, if that's the case, it's really not going to be a mistake that you're going to win on. It's really going to be competency, as long as they're not illiterate. Fraud, that's also very rare in the case law. I've never seen it. That's where out of the, the presence of the signing ceremony, there's a lie told, a story that's not true, with the intention of misleading the testator. There's deceit there, and they causes them to make a different devise than they normally would. So fraud, I don't think happens very frequently either. And duress is kind of a undue influence element. It's pretty hard to show duress. The case law really parses out undue influence, so I think that's why undue influence is probably more frequently used, but duress really is, in my opinion, a very close cousin to undue influence. An example is a threat of blackmail or force, beating up the testator if they don't sign this will, and you're never going to see that in front of the attorney. So let's talk about practical approaches. One that I really like, and this is a nationwide doctrine as well, it's called dependent relative revocation. Some states it's stronger than others. My state, Florida, it's very strong. That says if there's a string of wills executed by a testator, say there's 5 wills, and the 5th will is overturned, as long as it's substantially similar or even vaguely similar to number 5 is vaguely similar to number 4, well, 4 is revived. And if 4 is overcome by undue influence or lack of capacity, then 3 is revived. That's the presumption. So if there is a situation where you're pretty sure there's going to be a contest, you should probably put a string of wills or trusts together. Amend and restate them. Don't just amend them. I prefer amending and restating both a will and, amending and restating of trust, and then just do a whole new will, not doing a codicil. And that doctrine of dependent relative revocation will put roadblocks in the way of any potential contest. Quite challenging roadblocks. Another thing that we do in my office is to execute duplicate originals. We hold one. I don't hold the original hostage. I think that's wrong. That's in the hope that you're going to get the probate. But we do duplicate originals. Give one to the client. We have them sign a receipt, but we also hold another one. And what that does is it helps them if they accidentally lose theirs, but it also insulates them of a claim that the missing will was obviously revoked or it wouldn't be missing. And missing wills come up all the time, and this has happened, this prescription has happened to help a lot of clients over the years, because they do come up missing because somebody has access and they don't like it and they tear it up. So we have the original, we have a duplicate original. If they did want to revoke it, the argument is, well, they would have told the attorney, so the attorney would revoke theirs as well. I probably don't even need to say this. After going through all those Carpenter factors, keep the beneficiaries out of the room, especially at the signing, and maybe at the discussion of the will contents. I mean, use your common sense. If there's 3 kids and they're all getting equal amounts, pile them all into the conference room. I mean, it's good business to have them in there, if nothing else. They get to know you. They get to bond with you. They'll refer their friends, come back to you for the administration, but also they help mom or dad make decisions, and I think it's really important. It's really important that they have a team helping them out, not just trying to do it on their own. So don't overdo this undue influence consideration. I like having the family together during the discussion. So there's a couple of problem areas that come up over and over and over again. That's tangible personal property and loans, by the way. Loans are advancements to the family members. So you really need to address the tangible personal property. Very regularly, there's a lot of jealousy among family members. If it's an only kid, it almost never comes up. But the more kids there are, the more chances there are for disputes with tangible personal property. And for some reason, it seems like the kids that are military brats, it's worse because they've traveled around the world. They've got I'm a military brat, by the way. We've got all these memories of being in certain places around the world, and mom and dad could only buy so much shtick of stuff to bring back, and we all want it, you know. And so really start giving it away during lifetime or handle it in a separate writing. Give instructions, talk to kids, let everybody know what's going on, because once you're gone, that's when the squabbling starts, unless you've had a very good conversation with the family about all kinds of things, but tangible personal property is one, burial instructions is another. What are other things that are sticking points? When there's a vacation home. Trying to keep away from war stories here, but when there's a vacation home and there's a bunch of kids and dad remembers all the fun years back at that home on the lake in Michigan. He wants to keep that family home, or that vacation home in the family for generations. Well, that's not going to work. You know, you're going to have some kids that are going to use it, some that aren't. Everyone's going to, doesn't want to pay equally if they're not using it equally. Scheduling's a problem. What about grandkids? What about spouses of grandkids? It really gets to be a difficult, sticky situation, especially as time rolls on. So unless you're Einstein about the whole thing, unless your client is Einstein about the whole thing, it's probably going to be a sticking point to try to keep that vacation home after that first generation's gone. Family businesses, likewise, unless all kids are participating equally, there's usually going to be one or two of the several kids that are involved in the family business, and the other ones that are left out of that, the giving that the progeny the gift, they're going to feel slighted. So family businesses really need to be addressed early on with buy-sell agreements and a variety of techniques that need to be discussed fully with the family. Special needs kids, developmentally disabled kids, that can also be a problem because mom or dad, rightfully so, feel like the well kids, the ones without the disability, can take care of themselves. They've probably been helped through college to make them self-sufficient. We're talking about assets in the special needs kid, getting more maybe than the other kids, but also who's going to take care of that special needs kid? Who's going to make sure that their affairs are handled? And not to be forgotten is the requirement for special needs trusts for any kids that are on government programs, government needs-based programs. We're almost done here. I mentioned gifts and loans. I can't tell you how often that comes up. It's the parents' right to gift unequally to kids. Make a loan a gift at one point, but make sure that if there are any unpaid loans from mom and dad, and they want them repaid or don't want them repaid, put it in the document, because lawyers make a lot of money off of this argument here. Loans and gifts are one of those things that go under the radar when you're drafting. You don't always know about it. But if you get in the habit of asking about loans and gifts, put it on your intake form, your plan will be better drafted for it. And lastly, the blended family situation, we could do a whole presentation on that, but I'll just keep it to the point of view. Blended family meaning second or third or fourth spouse, kids of prior marriage. Anybody that's been doing this for 6 months realizes the unique nature of a blended family. Actually, I find it quite interesting and challenging. I prefer that over a beaver cleaver family because it's just, it's just different. But pick your fiduciary correctly. If you've got the surviving spouse looking over the wealth, the kids of the prior marriage are going to be very jealous. If you've got the kids of the prior marriage looking over the wealth for the benefit of the second spouse, they're not going to be too generous. There's going to be conflicts there. There's no one right or wrong answer, but a professional trustee might be the situation there. But your conversation with the blended family couple is going to be a lot more involved and should be. So with that, hopefully we've been able to parse through some approaches to drafting that you might not have thought of, and I appreciate your time.